So we are starting the session. We're starting the session on excess. We will discuss two papers. Our first paper will be presented by its author, Simon Stern, from the University of Toronto. I won't enumerate all his achievements, but just mention here that he teaches both in the law school and in the English department, which makes him especially appropriate for this conference. And before I'll give you the stage, I'll just say that I apologize that I couldn't attend the other panels. I heard they were wonderful, but it's a really busy time of right after the semester. So please, Simon, the floor is yours.
All right, thanks very much. So I'll just mention perfunctorily that I've been working with a bunch of legal historians for several years now on an edition of Blackstone's commentaries, which will be published by Oxford at the end of next year, and that's what motivates the focus on Blackstone in particular here. And maybe as the paper goes on, I might just say a few things that are related to the edition. So what I tried to do in the paper, there are three moves. I begin by talking about what I see as a fairly typical move in discussions of legal aesthetics, which is to specify legal aesthetics in terms of certain aesthetic effects rather than techniques. And I suggested if we focus on techniques rather than effects, you get a more concrete sense of what's at stake in talking about legal aesthetics to begin with. So there's a common move, sort of parallel to scholarship in critical legal studies, by which people who write on legal aesthetics reveal that although the law purports to have no aesthetic, it does have an aesthetic, and then the revelation turns out to be that it's an aesthetic of balance, symmetry, congruence, proportionality, other things like that. And it seems to me that if that revelation, if the demonstration that law actually has aesthetic biases is a demonstration of certain aesthetic effects, then it's sort of hard to get at why this is significant. Whereas if you focus on aesthetic techniques, you get a stronger sense of why it would matter that lawyers make arguments or judges write decisions in ways that reflect either aesthetic techniques that were dominant in 18th century aesthetics or contemporary aesthetics. And so I tried to give that some density. I then tried to categorize what I see as three prevalent types of scholarship in legal aesthetics at present, and then finally I turned to the example of Blackstone in order to elaborate what I see as that third mode of scholarship in legal aesthetics. So I'll briefly speak about what these three modes are, and then explain why I think that Blackstone's text, which in many ways seems banal and full of the obvious, and perhaps not even all that interesting from an aesthetic point of view, is actually, I think, responsible for the initiation of what I call relational aesthetics in this typology that I set up. So as I say, I think there are three kinds of things. I'm sure there are more than three, but a rough and ready typology would give you three modes of scholarship that are going on at present in legal aesthetics. One involves what I call the material aesthetics of legal actors and institutions, which looks at courtroom architecture, legal regalia. This is almost invariably historical in orientation, because it's obviously very hard to talk about these things without being at least somewhat historical. If you're talking about judges' wigs and how they've changed, or why judges wear black robes and other things that judges wear rather than black robes, and the ways in which certain kinds of architectural styles have inflected the architecture of courtrooms in ways that align the different actors and saddle them with different levels of authority. So it seems to me a fair amount of the work quite explicitly takes aesthetics as its object by talking about, as I say, these legal institutions. Sometimes this goes further. It looks at things like lawyers' offices or bureaucratic offices or various other sites in which law and legal advice are given, but for the most part, it tends to be relatively institutional in its focus. The second mode is what I call doctrinal aesthetics. So this is a mode of scholarship that looks at particular areas of law, zoning law, copyright law, especially various modes of intellectual property law, and shows that there's some theory of aesthetics, often tacitly at work, which explains how the doctrine works. So why is it we protect some things but not others in copyright law? Well, we've got a theory of intention, which is related to a concept of originality, and only those things that manifest the intention to be original, no matter how low you set that threshold of originality, only those things that manifest the intention to be original get to count as protected by copyright in the first place. And so there are a whole series of, I think, relatively obvious and some more improbable areas where it turns out that some theory of aesthetics is at work, and I try to elaborate some of these very briefly in the paper. Battles over literature, modernist literature, and aesthetics to do with obscenity. Less obviously, perhaps, in zoning law. And so I give this example of the weird-looking voting district, the voting district that was famously described as looking like a squash bug. And the fact that it looks like a squash bug itself gives rise to a presumption that there's some form of gerrymandering going on, such that more than one court, in fact, has focused on characteristics like that in order to say that unless the voting district board can give an extraordinarily good reason for carving out a voting district that looks like that, it's presumptively unacceptable. And then, last of all, what seems to me like one of the sort of growth industries in legal aesthetics at present, this is what I call relational aesthetics, and this is a form of scholarship that looks at relations between doctrines, relations between actors, relations between certain aspects of the trial process in some legal system, and then by putting them in relation to each other, talks about the aesthetic that's produced through this relationship. So on this view, and this is actually, again, often at work, I think, in contemporary legal scholarship that doesn't openly wear its aesthetic leanings on its sleeve, an argument for the reform of some doctrine is to locate it within the landscape of that area of law and to show that it's out of sync in some way. It bears an improper relation to the other doctrines or other procedures in that area of law. And so, although often the ground for explaining that it needs to be reformed would be a ground like it's inconsistent or something like that, I think ultimately one might even understand that sort of complaint as reflecting some idea about the proper relation among doctrines in this area of law. And so I give a number of examples of this. This is on page 10 of the draft. They're chosen more or less arbitrarily. The fact is there are easily 20 or 25 versions of this that I could have quoted, because this is an extremely common way of talking about how it is that some observer knows that something is out of sync or needs to be realigned or needs to be corrected. So as I say, I give a few examples here, but I think this is quite prevalent. And what I then try to do in the paper is to try to give an account of how this third mode, the relational aesthetics, came about. And it's for that reason that I turned to Blackstone, and it seems to me that the reason why Blackstone's commentary is helpful here is because Blackstone, writing his commentaries for publishing the first edition in the second half of the 1760s, is trying, in fact, not for the first time to give a comprehensive overview on English law, but certainly for the first time to give a comprehensive overview that's concerned with this notion of proper relations among the various parts of the system. And the reason why we know that there's something different about Blackstone's account is that the next most readily identifiable account that's available is that of Cook from a century and a half earlier. And Cook's account is highly digressive, highly circuitous. It's a commentary. It begins as a commentary on Littleton. So volume 1 of Cook's Institutes, also called Cook on Littleton, is a series of commentaries by Cook on Littleton's tenures. I give an example of that. It's the very end of the paper. Which figure is that? It is figure 3 is from the first edition of Cook on Littleton. And I've put up this rather than what I gave as figure 4, because the figure 4 that I gave, I'm sorry to say, was drawn in the 1792 edition of Blackstone, not the 1766 edition of Volume 2. And what you'll notice if you compare the two is that the Christian edition from 1792 has another layer of commentary at the bottom. And the point I was trying to make in contrasting what I meant to give as the first edition against Cook on Littleton is precisely the difference between what you might see as Cook's text serving as the sort of Gothic castle that stands in need of modern renovation in exactly the same way that Blackstone speaks about the common law as always needing to be reformed and made convenient for modern use. And so what you see here is a much more streamlined text, right? It's just got one set of citations at the bottom, so the comments and the citations are aligned, organized. We get a narrative text that's well organized, that flows, that's got a reason for the structure in the main text, and there's none of this having to move between the law French and the English and the commentary and the citations in the way that makes the navigation of Cook's page highly elaborate and circuitous and I think much harder to manage. So my thought is that in a number of ways, although what Blackstone does might to us seem so familiar as to go completely without remark, it seems to me that what's notable about his effort is precisely this idea that there's an order to the commentary. It's all structured in a way that would now be familiar to lawyers. He begins by saying what he's going to cover in a particular chapter. There's a logic to the structure of the whole volume. Everything is explained on grounds that make the doctrines proportion to each other. And what I try to do in the last part of the paper is understand some of the criticisms of Blackstone's text in relation to the motivation that he brings to the text himself. So sometimes people sometimes complain that this is actually not a helpful book for the working lawyer. It's not doctrinal enough. Well, he explains quite clearly that he doesn't mean it to be that, and on the account that I've just given, there's a good reason why it wouldn't be that. Since he's trying to map the territories, he says he doesn't want the map to be too clouded with particular details. He wants people to understand the general lineaments. People also complain that he praises the law as it is. Everything as it should be, Blackstone, as Bentham famously said. And again, since it's Blackstone's motive to explain why it all makes sense, there's a good reason why, even though he begins by saying that one of the values of this approach is that it allows you to suggest reforms, he barely suggests reforms at all, and the reforms that he does suggest tend to be in the direction of making criminal punishment more proportional, which is to say the kind of realigning, correcting move which is precisely consistent with the sort of aesthetic that I've described. And finally, I think one other way that Blackstone might be usefully contrasted against formalists whom he's sometimes compared to, such as Langdell, is that Blackstone's effort to make all of these things align well, radiate with each other, capable of being placed in their proper relation to each other, is precisely focused on taking the law as it is, making everything on the surface cohere, whereas Langdell articulates a motive which would be much dearer to the hearts of modern law professors, namely that of looking at what's at the surface, trying to figure out what the underlying principles are, and often trying to derive underlying principles that aren't at all visible on the face of it, whereas Blackstone is much more interested in explaining how it all works on the face of it. So I think I might just stop there and ask you to take over. Thank you.